Hello and welcome everyone to my presentation on latent defects and limitation liability in construction contracts. I'm excited to talk today on this critical topic. This subject is highly important from the employers, end users, and contractors' perspective, as they should be aware at all times of the limitation period within which all actions must be commenced. Limitation periods vary under the specific legislations of different countries. I will also discuss decisional liability insurance, which is applied in Middle Eastern countries. Decisional liability insurance is used to guarantee against structure collapse. The Latent Damage Act of England and Wales introduced a qualification to the period of limitation in order to overcome the possibility that a situation causing loss or damage occurred without the claimant being aware of it. The Act introduced a long stop provision starting a claim for damage for negligence under tort could be submitted within a period of 15 years from the accrual of cause of action, provided that it was brought within 3 years from the date of recoverability, that is the date of claimant become aware. I am going to talk on all these issues briefly from legal perspective of English as well as civil law jurisdictions. Definition of latent defects. In the construction projects, defects caused by failures in design, materials, and workmanship which are not readily detectable even with the exercise of reasonable care within or long after the end of the defects liability period. Such defects are known as latent defects. A latent defect may not arise for many years after defects liability period. As a result of this time lapse, limitation becomes a live issue within many construction disputes. It is a central issue to be considered whether you are thinking of bringing a latent defect claim, and is also a useful argument to raise when defending a latent defect claim. Examples of common latent defects include defective basement tanks causing water penetration, improper wind posts and wall ties causing movement and consequent damage to walls, understrength concrete or wrongly placed reinforcement allowing movement and causing damage to the structure, under-designed foundations causing subsidence of the building. Patent defects versus latent defects. A patent defect is defined as a defect that is visible or can be identified through reasonable inspection prior to the completion of the project or during the defects liability period. Latent defect is a defect that is not possible to discover through reasonable inspection and research before the expiry of the defects liability period. Time limitations under English law. The claimant is obliged to submit its claim on the date on which the cause of action arose under the Limitation Act 1980 of UK, related to a simple contract within 6 years. However, if the contract is executed as a deed agreement, the claimant can file the claim within 12 years from the date when the cause of action arose. The common law cases acknowledge that the time starts from the date of the breach of contract, not from the date on which the breach is discovered. In contracts under tort law, the 6 year period starts from the date the damage has occurred, which may not be the date on which the negligence was committed. The provisions of the Latent Defects Act 1986 extended the period of limitation by 3 more years for claims arising under tort of negligence. Hence, under the Act, claimant has an additional 3 years to bring a claim when unable to raise within 6 years from when the damage was actually occurred. Parties are free to agree on limitation periods. Under the agreed period is shorter than as provided under Limitation Act. This agreement would be subject to a test of reasonableness under the Unfair Contract Terms Act 1977. Decennial liability insurance in civil law countries. In Middle East, decennial liability insurance is used for structural flaws. Decennial liability insurance is issued jointly by the contractor and the designer to guarantee against structural collapse. They become a sufficient threat to the strength and safety of the structure. The decennial liability period is 10 years from the date the project is awarded. The time limitation to file a case from the date the defects arose and the date the parties became aware varies from jurisdiction to jurisdiction. The extent of the damages insured varies with the jurisdiction. The concept of insurance is broader and a dedicated comprehensive study is advisable for full understanding of the insurance mechanism. Collateral warranty. Issuance of a collateral warranty for construction project is a common practice to tackle the claims initiated by the third parties or end users. Collateral warranty enables end users to enjoy the contractual benefits guaranteed in a contract. The collateral warranty mechanism ensures an extended contractual matrix for the end user who was not directly involved in the process of construction activities but came into the scene after occupying the projects for use. However, a contractor is advised not to warrant beyond the extent agreed in the original contract. Therefore, consequent losses suffered due to a latent defect cannot be claimed under collateral warranty. This is why application for tort is unavoidable to claim consequent losses irrespective of the presence of collateral warranty. Claim arising from latent defects. In situations where the employer is not the occupant of the property, this end user or third party face difficulty in suing for damages arising due to latent defects. As there is no direct contractual relationship between the end user and the contractor, pursuing a claim under contractual grounds is difficult and complex issue. In accordance with the RICS guidelines notes related to defects and rectifications, the most common route to pursue claims with reference to a latent defect is a contractual remedy in the law of contract. However, in the absence of a direct contractual relationship, the collateral warranty mechanism provides safeguard to end user concerning latent defect damages. Claim under law of tort. The end users can pursue latent defects damage under the law of tort. Under the contract, a contractor is required to deliver the services to the extent of the agreed scope with reasonable skill and care. Under UK common law, the standard of care expected from a professional entity or contractor or a person must be greater than the ordinary care. So, keeping in view this requirement, tests for a reasonable person are essential to determine the standard of care and skill expected from such entity or person. The reasonable steps taken by a contractor should be explored to determine whether reasonable care and skill were applied by such a contractor in delivering the services agreed in a contract. Privity of contract in English law. This point to be noted that in the absence of privity of contract in English law does not discharge parties to the construction contract from the liability. This implies that the liability of a party from defects is not limited to the contracting parties only. Third parties with an acquired interest in the project have the right to claim to be indemnified for breach of contract. In the case of Barnes and McBrown and Co., the court held that the plaintiff was entitled to sue for the defect in the structure he occupied, even though he was not the owner of the property. The negligence claims under tort law are difficult in the absence of a direct contractual relationship. Thank you.